Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's lecture is going to be on Chapter 2, and this covers the role of the courts. Yes, I know how simply excited you are, but it is an important piece and part of the entire criminal justice system that is impacted specifically and directly related to evidence and how those items of evidence are brought in and things that can happen during court cases and which court hears which case and to what level, and there's just a lot of information there. So with that being said, don't forget to take a moment and review the key terms that are at the beginning of the chapter and also the discussion questions which are at the end of the chapter. And as in previous chapters, please read the textbook to look at not just in detail more of the information that we're going to cover, but that's a good thing, but also perhaps some of the examples that are listed in the textbook, which will help you add some context to some of the definitions and things that we're going to go over as well. So with that being said, let's look at our featured case for the week. So in 1996, 3 people were killed in Winona, Mississippi. And numerous witnesses gave conflicting testimony as to whether the alleged suspect in this crime, Curtis Flowers, was in fact the suspect. And prosecutors during this case also committed a lot of errors requiring retrials and things like that. And after 6 different trials, Flowers was finally convicted and sentenced to death. Now I have a video from CNN that you can click on and you can go to and get a little bit more information about it. Also, if you look at the beginning of Chapter 2, it talks about some of the issues. And as far as prosecution goes, the prosecutor planned to have separate trials for the 4 murderers. And each of the 2 trials, each of the first 2 trials focused on a different victim. And 2 jailhouse informants testified that Flowers admitted to the shootings, and both of these witnesses later admitted lying. They admitted to lying under promise of monetary reward from law enforcement. And Flowers was convicted in both cases, but the verdicts were reversed by the Mississippi Supreme Court due to the prosecution's use of an excessive number of crime scene photos and testimony regarding those 2 victims. And Flowers had not been charged with the killing. And in 2004, a 3rd trial, the prosecutor used 12 preemptory challenges, which we'll talk about jury selection further down in some other chapters, to exclude African Americans, resulting in a jury with only 1 African American, and the city's population was 45% African American. And because of that, the conviction was reversed by the state appellate court because of the possibility of racial bias during jury selection. And the jurors at the 4th and 5th trials could not reach unanimous decisions, which is what, everybody? They call that a hung jury, meaning that they really can't reach a decision. And the 6th trial that was held in June 2010 resulted in convictions on 4 counts of capital murder, and Flowers was sentenced to death. And the trial judge denied a motion for a new trial, and the direct appeal has been pending before the Mississippi Supreme Court for about 2 years. So you can see that issues related to trials can cause problems later on. And then the other question that comes up is, how many trials is enough? So when you read that case study, what evidence points to the likelihood that Flowers is guilty, and what points to his innocence? And at what point do multiple trials become a violation, if you will, of double jeopardy and not a technical one? And because of a technical issue, should we allow a retrial? And there's just so many things to think about when it comes to this. So here's what we hope to learn or take from this chapter. Explain how checks and balances inside the U.S. Constitution apply to the courts, and define this phrase, independent judiciary, and sort of map out or chart the structure of a state court system, and explain how courts obtain jurisdiction. How do you know if it's going to be your case? Court-wise. And understand how statutes of limitations work, meaning how long has to pass before you can't file a case, or is that not even an issue? And how do we distinguish between trial and appellate courts, and what are the difference? And how many courts are there? And explain the difference of the levels of proof necessary in court. And we talked about some of those in chapter 1. And look at a little bit between federal and state courts, and compare and contrast what they call discretionary and direct appeals, and understand how cases are appealed to the Supreme Court. So if we want to go all the way up to the granddaddy of the courts, if you will, the U.S. Supreme Court, how do we get there? And then finally explain how this thing habeas corpus works, and looking at the impact of the Civil Rights Act of 1871 on the courts. So we've got a lot to kind of go over, and I think you're going to find it quite interesting. So the U.S. federal system of government results in two overlapping systems. The federal courts hear cases about federal laws and those arising on federal land. And prosecution of federal crimes occurs there among suits involving civil cases. And we know each state also has its own court system, and we'll kind of get to that. And to that extent, that an event occurring in a state has constitutional implications, such as a violation of the Fourth Amendment, that decision of federal courts are going to be binding. Now, I know that sounds confusing. So again, the U.S. federal system of government has kind of results in overlapping systems. We have that state and federal system. And the federal courts hear cases about federal laws and those arising on federal lands. Well, the states also have their own court system. So we've got these two things. Now, again, to the extent that an event occurs in a state, okay, to the extent that an event occurring in a state has constitutional implications, such as a violation of the Fourth Amendment, the decision of federal courts could and will be binding. So what does that mean, and how does that really kind of even fit into what we're talking about? Well, the first thing I'd like you to do would be to take a look at these links that I've included on court videos. And you can see that we've got a video on the Supreme Court and the circuit courts or court of appeals and district courts and the federal court system and the state court system. And yes, they're about 10 to 12 minutes each. And yes, they're probably not the most fantastic action-packed videos you've ever wanted to watch. But if you start at the state court system and kind of work your way up, you'll start to see how these court systems play a role and where they play a role as well. So again, really good thing that you should do would be to watch those videos. Now that we know that the system is kind of has those two overlapping systems, and we'll define them a little bit further visually in a moment, let's talk about the checks and balances that are there. Well, the U.S. Constitution established 3 branches of government. And in addition to giving each branch specific duties, there is a system of checks and balances in place. So each branch, the executive, the legislative, and the judicial branch, operates as a check on the power of the other branches, if you will. So those federal, judges, the judicial branch, are nominated by the president of the United States, and the executive branch must be confirmed by the Senate or the legislative branch, and the judicial system budget is established in a bill that must pass both houses of Congress and be signed by the president, and new federal laws must be approved by Congress and signed by the president, but the judicial branch can rule that they are unconstitutional, and most states have similar checks and balances within their system. So keep in mind now, okay, and we're going to try to simplify it. The federal Constitution has established those three branches, and we know these branches, the executive, the legislative, and the judicial branch. They each operate as a check and balance on the power of the other ones. And in addition, federal and state governments operate as a balance of power in that federal system of government. And with that comes this term called independent judiciary. Now, the United States takes pride in the independence of its judiciary. And in this sense, an independent judiciary means that although politicians appoint judges, they don't have the authority to remove them from the bench because of, let's say, unpopular decisions. And judges don't leave office when the party that appoints them possibly loses power, meaning that maybe the election comes around and they don't win. The judicial selection process follows several different models. So as we look at this independent judiciary, pay close attention to how it's formed. So federal judges are nominated by the president and confirmed by the Senate. And a simple majority vote is required. And once confirmed, the federal judges hold office during a period of what they call good behavior, which in most cases means until retirement. So judges don't leave office, and again, they don't leave office when that party possibly appoints them loses power. So an example that we can kind of look at would be when Trump was elected, he ran under the Republican Party. So those judges that were in place or that were put in place by a Democrat, they don't get taken out. They stay there until they retire. So hopefully that kind of makes sense, and you're following along with kind of what I'm saying. So federal judges, again, are nominated by the president and confirmed by the Senate, and a simple majority vote is all that's required. And once confirmed, they hold office basically until they retire. And the House of Representatives, of course, can impeach a federal judge for a conviction of treason, bribery, or other high crimes and misdemeanors, but typically they will stay in office until they age out or they retire or what have you. Now state judges, they do not serve for life. And in some states, the initial appointment is by the governor or judicial council. But after assuming office, the judges face election periodically. And in other states, a person can become a judge by winning an election only. And some states use both systems. And appellate judges are appointed by the governor, but again, trial judges are elected. Now, you're not going to have to know all of this information, and I know it's tough to follow. But if you're kind of following along in your textbook, you can make some highlights as we go along that will help you keep track. So those federal judges, again, appointed for life in the federal system. And the state judges are selected by a couple of different means or a variety, depending upon what state you're from. They're elected. They're appointed, then confirmed by an election. So a couple of different ways. And when we look at the court organization, you can look at this figure here that's found on page 29 in your textbook, and courts have a hierarchical, if you will, organization. And the basic structure is similar in the federal system, and I'll give you some graphs that look a little better than this one in a minute, but you'll get what I mean here. So the basic structure is similar in the federal system and most states, although the names might be different. And the most common name for the highest court is the Supreme Court. But some states like New York use that title for a lower court. So it kind of changes around a little bit. But the basic structure would be, as we kind of look at here, trial court, court of appeals, and then the Supreme Court. Now, when we're talking about state courts, and again, I'll look at a different diagram in a minute, every state has a Supreme Court. And I don't think a lot of people know that. So it starts with, if we're going to look at this as the state, you have a state or trial court or superior court, and then you have the Court of Appeals, and then you have the Supreme Court. That's per state. Now, federal kind of is the same thing, but you have district courts, and then you have the Court of Appeal, and then you have the U.S. Supreme Court. And again, don't get confused. I'll show you some different diagrams in just a moment. So along with the organization of the court comes what they call geographic location. So geography is the key to finding the right court. And the case must be filed in a court with what they call jurisdiction over the location where the crime occurred. And this is referred to as the court's geographic jurisdiction. So geography, again, is the key. And if the case is filed in the wrong court, the defense has the right to have it dismissed. And the rule is more complicated for crimes such as kidnappings and let's say telemarketing fraud, which occur in multiple locations. So you can see how that might be a little bit tougher. And the legislature establishes the boundaries for each court. And if you watch those videos, you'll see some of the districts and boundaries that I'm talking about. And in many states, the trial courts are organized by the county. There may be more than one courthouse if the county has a large population or driving time from the outlying areas to, say, the central location. And that would be really burdensome. And local authorities establish the boundaries called venue for each of the courthouses. So again, it's tough to kind of follow, but stay with me and it'll start to kind of clear itself up in just a moment. So let's look at the federal court structure for just a minute. Well, you know what? I think what I want to do is, no, let's look at the federal court structure and then we'll get to the rest. Each level of court serves a distinct purpose. And unfortunately, there's no consensus nationwide on what names apply to each level. So for the purpose of discussion in your text, it's going to be assumed that there are 3 tiers of courts, kind of like what we looked at in that diagram. And the lower court will be called the trial court, and the first level is the appellate court, or the Court of Appeals, and the highest court will be called the Supreme Court. So in the federal structure, as we see here, the United States Supreme Court is the highest court, and it hears only that middle level or appellate cases. And that middle level is the U.S. Court of Appeals, also called the appellate court. And sometimes they call it the circuit court. Now again, we're in the federal structure for a moment. And then the lower level is called the district court, kind of like trial courts, if you will. And there, again, so when you go back up to the middle, there's 12 regional circuits and there are 94 district courts. And there's only one United States Supreme Court. So here's a good graph that'll help you figure it out. These lower courts we looked at in the federal system So lowest level in the Fed system, there's 94 judicial districts in 50 states and territories. And the Court of Appeal, actually that's the proper name, it's not the Court of Appeals, it's the Court of Appeal. This is the intermediate level in the federal system. And there are 12 regional or circuit courts, including the DC circuit. And then finally, the federal Supreme Court, the highest court in the federal system, where there are 9 justices that meet in Washington, D.C. And the appeals process is through what they call a writ of certiorari, and we'll talk a little bit about that in further in the chapter, and that's the process that you have to go through in order to get a case heard at the United States Supreme Court. And they don't hear every case. Matter of fact, they hear very few. But they pick and choose the cases that they want to hear. So, when you talk about applying the law to the highest court, just some questions to kind of run through your mind before we move on. Who should be appointed to the Supreme Court, that highest court in the land? And should the judges be from diverse backgrounds? And what should qualify or disqualify a judge? And what should a judge be allowed to consider? Well, there's a link to a video that you can watch to get a little bit more of that information. Well, what about the court structure in the states? So we did the Fed. And again, it was kind of a brief overview, but that's okay. So let's look at the state court system. Well, again, we talked about that every state has a Supreme Court. So at the top would be the state Supreme Court. That's the highest state court. And then below that, you have the state court of appeals, and that reviews what happened in the lower court. So the state Supreme Court, the Supreme Court of each state has a limited but very important function, and most have one panel of justices who hear cases as a whole, and as a result, a relatively small number of cases are considered. And that state court of appeals reviews what occurred in the trial court below. And that state superior court is that trial court at the bottom that typically hears felony cases. And trial courts process the case from the time the charges are filed through sentencing, and most of the workload in these trial courts involves what they call pre-trial phase, getting ready for the trial and everything else, because again, only a small percentage of cases go to trial, and we learn that in the chapter before this. And then we have state district court, and these are trial courts. These are lower level that hear only misdemeanor cases, and then we have small claims. But for purposes of the book, remember, we're going to talk about the big 3. So not just on the federal side, but also on the state side. So for states, we have those trial courts, those superior courts, remember at the bottom? And then we have the courts of appeal right here. And then we have the state Supreme Court right there. So this is kind of a good overview on how the court systems actually kind of run. So kind of a review. State trial courts, well, they do handle most cases, and even those that don't go to formal trial. And they determine guilt or innocence. And they rule on admission of evidence. And these state trial courts are typically where officers are going to end up testifying on say, felony prelim cases at the state level. And that state court of appeals, now we know that they review the trial courts, and the state Supreme Court, well, that's the final review of the state trial and appellate cases. So hopefully this kind of review has helped you a little bit to kind of get a better understanding on some of these, on the differences in the court system. Now, along with this comes the statute of limitations. And the authority of the courts is also limited by what we call the statute of limitations enacted by the legislature. And the basic concept here is that it is unfair to leave criminal charges hanging over somebody their entire life, or indefinitely, or whichever comes first. Now, specific laws establish expiration dates for charges. And if charges are filed after the statute of limitation has run out, the defense has the right to have those charges dismissed. And murder, as an example, usually has no statute of limitation, meaning that it can be prosecuted at any time. And that's why you'll see a lot of cold case murder cases being worked, because as evidence becomes available and they possibly can get a case filed, well, then they can, because there is no statute of limitation, they can bring that case to court and bring somebody to trial and subsequently to justice. So you can see how that works. So misdemeanors, however, typically have a shorter statute of limitations, such as 1 year from the day, let's say, the crime was committed. And the limit on felonies is typically 3 years or longer. And many cases, or many states actually, will suspend that statute of limitations if the suspect flees the jurisdiction to avoid prosecution. So the common terminology is that a statute of limitation is tolled, and that's T-O-L-L-E-D if you're looking for the word. And so, for example, assume a suspect committed a crime with a 3-year statute of limitation and left the state for 6 months to avoid being arrested. Well, charges filed up to 3 years and 6 months after the crime, it would still be valid. So they'll toll, if you will, okay, that case until the person is brought to justice or comes back to the state. So hopefully that kind of makes sense. And a little bit more on the functions of federal courts, because I want to make sure that you have a good idea, because we did talk about state and we went through the levels of federal. Well, the federal district courts, remember, these here cases involving federal crimes and civil cases, and they are kind of, this is the bottom tier, and the Federal Court of Appeals, they oversee the trial courts, and then again, the U.S. Supreme Court rules on constitutionality of laws. And there's a case, Marbury versus Madison, that oversees the federal court system, but a little bit more on the Supreme Court after we take a look at Marbury versus Madison. So here in this case, the Supreme Court reviewed a law involving the appointment of a federal office holder, and that was Marbury. Now, the president at the time, Thomas Jefferson, refused to give Marbury his job due to political differences. And the Supreme Court declared in this case that, you know what, Marbury would be entitled to the job, and that they could actually order the president to do so, but the law establishing the position was unconstitutional. And this created that doctrine of judicial review, the power to declare a law unconstitutional. So this is a huge case. It really is. And even though it was back in 1803, the significance of this case really can't be understated. So at the bottom here, I have a video on Marbury versus Madison, and I would suggest that you watch the video. On the left is another link to kind of a case summary, but this link down here is a video, and it's kind of a lot cooler watching. So now back to the Supreme Court before we talk about judicial review and things like that. So some questions, I guess. Let me finish this. Should courts have the power to declare laws unconstitutional? Should they be able to do that? And isn't this power against the very concept of democracy? Hey, you know what? We made these laws, so why should the courts have the power to declare a law unconstitutional? And if the power of judicial review operates as a check on legislatures, well, then what checks the court's power? Well, now back to the U.S. Supreme Court and a little more on Marbury. So the U.S. Constitution does not explicitly give the courts the power to rule that laws are unconstitutional. And we know, because we just talked about it, the issue first came to the U.S. Supreme Court in 1804 in that case of Marbury versus Madison. And President John Adams signed a commission authorizing William Marbury, that's the one in this case, to serve as a justice of the peace for the District of Columbia. And Secretary of State James Madison affixed the official seal to the document but refused to deliver it. And then Marbury filed a petition for a writ of what they call mandamus to force Madison to deliver the document so he could assume office. And the court ruled that the federal law, which established the authority for the Supreme Court to hear the mandamus positions, was a conflict with the jurisdiction established by Title III of the Constitution, and therefore it could not order Madison to transmit the commission to Marbury. Excuse me. And it found that the court was duty-bound to declare acts of Congress void if they were in conflict to the Constitution. So, I mean, it sounds like a lot of hoopla, if you will. But you'll start to see how some of these case laws really play an impact on the entire criminal justice system and specifically law enforcement. So with that being said, let's look at the impact of these case laws. Not necessarily the Marbury case, but of case laws in general. So decisions by appellate courts are considered binding on subsequent cases. And this is called stare decisis. There's a word for it. And these early decisions are what we are referring to when we talk about case law. And a decision becomes precedent for later cases involving the same issue. So you can see the impact of how these cases could they could be on our system. Now, a higher court can vacate or reverse decisions of courts below it in the organizational chart that I showed you. And if this has not occurred, an appellate court can overrule its own earlier decisions. And when there is no precedent, a judge may consider cases that are not binding on the case, like out-of-state cases or those from other appellate districts, and make a similar ruling. The impact of Supreme Court decisions is pretty easy to understand overall, and an example will help clarify the role of precedent in the intermediate level appellate courts. So here's kind of an example to help you. Assume that the state legislature has passed no laws involving let's say physician-patient privilege. The Court of Appeals for the First District held that physician-patient privilege does not apply in criminal trials. And the Court of Appeals for the Second District held that the physician-patient privilege applies in criminal matters except when the doctor was consulted to help the patient commit a crime. If defendant X commits a crime in County A, whose trial courts must follow the precedents from the First District? The physician-patient privilege cannot be claimed. If defendant X's offense was perpetrated in County C, which is located in the Second District, the privilege can be used unless the doctor was consulted to help defendant X commit the crime. The Court of Appeals for the Second District could in fact overrule its prior decision and hold that the privilege does not apply in criminal cases. And this would result in both the First and the Second Districts having the same rule. If defendant X lost his direct appeal in the First District but successfully appealed to the state Supreme Court, the ruling on the use of physician-patient privilege in criminal cases would apply to all courts in the state. Now, again, I know confusing, but it's kind of tough, and that's why you really have to read to gain some context. So let's kind of continue on and look at evidentiary standards used by courts. So courts review evidence based on several different standards, and at early stages of the prosecution, it may be sufficient to show that it is more likely than not the defendant committed a crime. Now remember, a conviction requires a much higher level of proof. The first step in the review process is triggered when opposing counsel makes an objection. And for some issues, such as whether a police search was legal, this is done by filing a motion with the court before trial. During a court hearing, when a witness is testifying, the appropriate procedure for opposing counsel to make an objection to a specific question that a witness has been asked. The appropriate timing for this objection is after the question is asked, but before the witness answers. And this is called the contemporaneous objection rule. So that's a lot of stuff, so let's kind of rehash. It's the timely and proper objection to the admission of evidence that must be made at a trial in order for the issue of admissibility to be considered on appeal. So any objection should be made before an answer. And that definition is also in your book. Now, in some situations, the objection is so obvious that the judge rules on it like right away, kind of instantaneously. And more commonly, each attorney is allowed to kind of give their reasons why the objection should or should not be sustained, after which the judge will make a ruling. Now during the pre-trial stage, the judge may be called upon to make a variety of rulings on evidence. In felony cases, either a judge or grand jury reviews the evidence to determine if the prosecution has sufficient facts to warrant taking the case to trial. Now, ironically, this review may rely on facts that may not be admissible at trial because of the hearsay rule, the exclusionary rule, or other reasons. Now, these initial reviews require the prosecution to show that a minimal amount of evidence is present. And that is called a prima facie case. So defined prima facie, a definition would be a party's production of enough evidence to allow the judge to infer the fact at issue and rule in the party's favor. In practice, a prima facie case and probable cause are kind of equivalent. And suppression motions are usually heard before trial. The judge will hear testimony about the procedures used by the police to seize this evidence or obtain a confession, and rule on the defense's request to exclude evidence from trial. Now, the prosecution normally has to establish by what they call a preponderance of evidence that the procedures were conducted properly. So this is another evidentiary standard. We're still on this evidentiary standard that's used by courts. So we talk about the preponderance of evidence. The prosecution, again, has to show that, you know what, proper procedures were followed by police in seizing evidence or obtaining a confession. And the judge will typically hear testimony on the admissibility of this and then rule on the defense's motion or request to exclude evidence at trial. So when you've heard, like in a court setting, the defense attorney say, like, I object, or something. This is the contemporaneous objection rule, where before somebody answers, let's say when they're testifying in court, this rule comes into play where you're going to make the objection before the person answers. And then sometimes in some situations the attorneys get to kind of assert and argue back and forth why their objection should be sustained or not sustained, and the judge will make a ruling. And then at sometimes during the pre-trial stage, so before the trial, if there's an issue of admissibility, okay, there'll be basically a hearing, if you will, on that. And the judge will be called upon to rule on whether or not there's a prima facie case, or whether the prosecution has shown that the procedures for obtaining evidence were proper or not. So I hope that kind of makes sense as we're working through this. And remember that that level is that preponderance of evidence, which means the greater weight of the evidence, not necessarily established by the great number of witnesses testifying to a fact, but by the evidence that has the most convincing force. Superior evidentiary weight that, though not sufficient to free the mind wholly from all reasonable doubt, is still sufficient to incline a fair and impartial mind to one side of the issue rather than the other. And then, of course, we know that the constitutional standard for conviction is proof beyond a reasonable doubt. So while absolute certainty is not required, all reasonable doubt needs to be basically eliminated. And then plea bargaining, we kind of mentioned this a little bit. And this results in those pre-trial hearings as well. And the results of these pre-trial hearings have a disproportionate impact on the criminal justice system, because once made, attorneys can look to plea bargain, and plea bargaining is basically an agreement between the defense and the prosecution on the terms of a disposition of a case. And a little bit of review, but again, it's okay to look at it again, that the evidentiary standard by courts for conviction is beyond a reasonable doubt. That's the constitutional standard. Now probable cause, if you want to kind of compare it, probable cause is defined as more than not, requires about 51% certainty to meet beyond a reasonable doubt. The facts would need to almost be 100% certainty, so you can kind of see the differences in those two. So what about the post-conviction proceedings? What happens like at the end? And some terms that we're going to go over. Well, first of note is, after the jury votes to convict, we do need to know that the trial judge does have the authority to set aside the verdict, and that's a term. And a new trial is usually ordered, although the judge does have the authority to enter an acquittal. So that's one thing that can take place, but other things happen at the post-conviction proceeding. And once a trial court has concluded its actions, there are a variety of avenues available to a defendant. And an immediate appeal to the next higher court is called a direct appeal. And this direct appeal is the best known and most frequently used. In most cases, there is the possibility of an appeal to at least one higher court after this, but a case is heard only if the higher court grants the request. And if constitutional issues are involved, it may be possible to appeal a state court conviction to the U.S. Supreme Court. So a couple of other things that are in there. So, appeals a lot of times are based on matters of law, not fact. So they're not going to retry the case. So understand that. These cases are based on matters of law, not matters of fact. So the side that loses in the trial court has the option to appeal to a higher court. And when a defendant is acquitted, something else happens. Double jeopardy prevents the prosecution from refiling those charges. So that's one reason why the prosecution rarely appeals on certain cases. So for vocabulary purposes, the defendant on the appeal is called the appellant, and the prosecution on appeal is called the respondent. And trial records are called clerk's transcript. And word for word record is called the reporter's transcript. So you can kind of get some definitions in there. Now, if you want some examples of issues that can be raised on appeal, you can look on page 38 in your textbook, and there are some examples of issues that can be raised and issues that cannot be raised. And I'll let you take the time to kind of look at those. So what about the appeal? Well, it's first, the first appeal, again, is typically granted as a matter of right. And each appeal or each side submits a written argument for or against the appeal, and those are referred to as briefs. And it's not unusual for the appellant to successfully establish that an error has occurred in the trial court, but still lose the appeal. So an error doesn't automatically mean a new trial. And this is because of what they call the harmless error rule, which is based on the premise that errors occur at virtually all trials, and therefore a case should only be reversed only if the appellate court is convinced that the errors contributed to the outcome of the case in a significant way. And when constitutional issues are involved, the U.S. Supreme Court ruled that the case need only be reversed if the judges are convinced beyond a reasonable doubt that the error affected the verdict. And there are few exceptions, such as denial of Sixth Amendment right to counsel, that require an automatic reversal. So that's a little bit of kind of the appeal and the direct appeal. Well, what about something called a discretionary appeal? Well, again, there's no right to a second appeal. And assuming the side that lost the first appeal wants to take the case to a higher court, a formal brief again is prepared stating the issues and requesting a hearing. And this is called a discretionary appeal because the justices of the higher court, they get to vote on whether or not they want to hear the case. And state law specifies how many votes are required, mandating 4 out of 7 is common. And one of the key differences when requesting a discretional appeal is that the attorneys argue the importance of the case to the legal system and society rather than focusing solely on the person who was convicted. If it's just another drug case, the justices are unlikely to grant a hearing even if they believe the lower court's decision was wrong. The attorneys requesting the hearing are more likely to argue the policy implications of what occurred in the lower court. And another argument that may be may convince the higher court to review the case is that the lower appellate courts had conflicting precedents, let's say, on the issue. So these are issues related, again, to appeals. Well, what about all the way up to the big one? And getting a case all the way to the U.S. Supreme Court. Well, the U.S. Supreme Court will only consider cases involving constitutional issues that have gone through normal channels first, and this is called exhaustion of remedies. For defendants convicted in state court, the direct appeal and petitions for discretionary review by the state's court must be complete before asking the U.S. Supreme Court for a hearing. Now, defendants convicted in federal court must also exhaust all of their remedies before taking the case to the U.S. Supreme Court. Now, the chances of hearing being granted are pretty slim, and well over 3,000 petitions are received each year, but less than 100 cases will receive full hearings. And the process by which of requesting that the U.S. Supreme Court hear a case starts with something called a petition for writ of certiorari, frequently called a cert. And the party that wants a hearing files a petition stating the constitutional issues to be considered. And the petition for cert is frequently accompanied by a request to proceed in what they call forma pauperis. And the purpose of this request is to obtain a waiver of some of the formalities that make the cost of the petition in court kind of prohibitive. And to kind of continue, the 9 justices review the incoming petitions with help from their law clerks, and the justices will then meet as a group, and they vote on them. And the cases that receive 4 votes are scheduled for oral arguments, and this is referred to as granting cert. And the issues to be briefed will be stated by the court at that time. So that's why it's good to look at, again, those court videos. And here's one to a link to the U.S. Supreme Court that talks a little bit about, what the Supreme Court does and how the Supreme Court came about. So a little quick review here, some other petitions. We talked about that word forma pauperis, which means kind of a waiver of formalities. And a definition called amicus curiae, which is friend of the court, a petition in favor of one side. And when we talk about, again, hearing the case, the court hears an oral argument from opposing counsel, and then the majority of justices will then write its decision or opinion. And this is what comes out of these U.S. Supreme Court cases. Well, a couple of other terms that we want to get through before we conclude would be something called habeas corpus. And this is a civil lawsuit filed in trial court to challenge illegal confinement. And being in jail, in prison, or on probation or on parole due to an improper conviction fits this category. So does failure to release an inmate after their sentence is done, completed. And involuntary confinement of, let's say, a mentally competent person in a mental facility. So all of those instances would apply. Now, unlike a direct appeal, which must be filed within a specified time period after conviction, habeas corpus can be filed whenever the situation merits it, so before or after trial. And in habeas corpus proceedings, the judge can order that the person be released from custody or that the conditions of confinement should be changed. Now, a conviction cannot be reversed, nor can monetary damages that were awarded. but the other things can. And there are some examples of issues that should be raised by habeas corpus and should not be raised by habeas corpus on page 43 in your textbook. So finally, let's finish up with the Civil Rights Act of 1871. So the Civil Rights Act of 1871 was enacted in the post-Civil War environment to prevent partisan Southern judges from ignoring newly enacted rights under the 13th, 14th, and 15th Amendments. And in the 1960s, the use of these laws was expanded to cover all constitutional rights. Since then, sections 1983 and 1985 have been used extensively to seek redress or monetary compensation for constitutional violations by criminal justice personnel as well as by government employees. Now, Section 1983 applies to state but not federal government personnel. But the Supreme Court, in a case called Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, made similar redress, and we've already identified what that means, means compensation, available to individuals whose rights were violated by federal officers. And these actions are sometimes called, for short, they call them Bivens suits or constitutional torts. And it must be noted that Civil Rights Act cases can result in the award of money. Remember, I kind of mentioned that. Injunctions or other civil types of relief, but the judge cannot order someone to be released from jail or modify the length of a sentence under this particular component that we're talking about. So on page 45, there are some key provisions for Section 1983 and also 1985. Now, the Supreme Court has taken a historical perspective when dealing or deciding who should have immunity under the Civil Rights Act. And this results in two types of immunity largely based on job function. And an absolute immunity applies to judges and prosecutors when acting in their official roles regardless of their state of mind. When they step outside the role, they have qualified immunity. And a witness has absolute immunity while testifying before a grand jury or in court, even when they knowingly give false statements. And absolute immunity means a Civil Rights Act case would be dismissed, or other actions such as perjury, prosecution need not be dismissed. Now, most other state and local government employees have what they call qualified immunity. And if it can be shown that their actions were taken in good faith, the case will be dismissed. And good faith has two prongs as well. The person objectively believed that the actions were constitutional and efforts had been made to remain current on Supreme Court decisions and other relevant laws. And qualified immunity is not available if the person knew or reasonably should have known that the action they took within that sphere of the official responsibility would have in fact violated somebody's constitutional rights. So a lot to know. And on page 47 are examples of cases that have immunity under Civil Rights Act and cases that don't have immunity. So this is the Bivens case that I talked about. And this is where federal narcotics agents searched a home without a warrant and arrested Bivens. And after charges were dismissed, Bivens sued the agents claiming a violation of the Fourth Amendment. And the Supreme Court recognized a new clause as a result here. The cause of action, if you will, Bivens, when federal agents violated the Fourth or violated his Fourth Amendment rights. And then remember, this is a civil, not criminal remedy, and you can click on the link to take you to a little bit more information about it if you so desire. So we'll there we go. So we made it right at the 60-minute mark, so not bad. So don't forget to utilize the student resources, the key terms at the beginning of the chapter, and also the discussion questions at the end of the chapter. If you have any other questions, feel free to post them on the discussion board, or if you don't want to do that, you can email them to me and I'd be happy to get back to you. So with that being said, that will be the end of our Chapter 2 lecture on the role of the courts.